Yes, welcome to the today class of JCJ 2022 main examination. And here I could see that people are present, but slowly they are joining it. And host are three, and Gausia is only the participant. SR Varana is host, and KSB is host, and Mohammed Saheb Hussain is host.
Participant only one.
What is that saying? Muddai sust gawa chust. Something was there. What was that? The pleader is, I think, Muddai. Muddai means plaintiff.
Plaintiff.
Then gawa means witness.
Yes.
Anyway, doesn't matter because our count starts with 0, but at least 1 is there. So we should be happy. So now, Venanath, we want to say something.
Let sir complete. Let sir come. We'll see how many people will turn
But
up.
I told you the audio visual effect. It is having the high impact.
Yeah, but
Audio and visual effect having the
that's true.
a
But
big impact.
I come late from office, so
Here today I would like to do the negotiable instruments, but I don't know where my file disappeared. But anyway, the Specific Relief Act 1963. You want to say on that section 34?
yeah, I'll only talk about.
Yes, please go ahead.
I'll only talk about section 34, which is interrelated with CRPC.
Say loudly because I could hear your sound very low.
Okay, 1 minute. Let me increase the sound.
I think I have to increase the sound. Something was it. Okay, now I increase my sound because I decreased my sound. Now I increase it. Now you go ahead.
Okay, I'll be talking about section 34 of SRA Act, that is interrelated with Indian Evidence Act 112 and CRPC. All this comes on, and DNA. DNA is not daily news and analysis. DNA is a test conducted for some specific reasons. So I'll be talking about on those things only, because section 34 is related to all these things. Okay. You want me to talk? You want me to wait for someone else to join?
No. You speak because your vision is not there. Audio is there. That's why it's less impact. Anyway, you speak. I will try to make it out section 34 meanwhile. Okay, proceed.
Section 34 is declaration of suit under Specific Relief Act, which means, what does section 34 says? You should file for any declaration of a suit, means for any, you're asking for some declaration to be done by the opposite party. Okay. And this is related with, you have to correlate section 34 and 112 of Indian Evidence Act. Then only these two, when these two sections club, then only you can prove section 34 or 112. Okay, now what section 34 deals with is that for the first time in India, there was a case which was Nandalal Vasudev versus Lata Nandalal and others in 2014, where the Honorable Supreme Court has directed for a DNA test under section 112. The child has filed a petition under section 34 of SRA Act for the father to do some specific performance. What is that specific performance? Prior to 2014, January 6th, DNA test was not allowed in India.
Is it which has shown the same 34?
1 second, sir. I can't
Specific Relief Act.
I can see your screen only. I can see only your face. I can't see.
No. I will share. I will share just now. Yeah, now check.
ये तो negotiable instrument act है. Section. Yeah, can you enlarge it?
Yeah. I will do it. I will see where the provisions are there. Yes.
Yes, there.
But I have to drag it to a certain extent. I don't know why this is this much only. Okay, let me drag it. Oh, it is gone.
No, it's okay.
No,
It's a
this is a different. This is a different. This actually that I want to show you. 100%, but it comes very side.
You enlarge it from here. From here, it is.
See, when you enlarge it now, it is going to the one hand side,
No,
one
no,
side.
no, no, no. सर आपका फोटो है ना, आपका फोटो पर एक स्क्वायर बॉक्स है, देखो उसको enlarge कीजिए आप.
See, this it cannot be enlarged.
वो नहीं सर, आपका फोटो किधर है आपका स्क्रीन पे?
That my photo, I did not make it out my photo here, but automatically it will come default. Yes,
है.
let me try for that one again. Section 34. That is the reason I told you. Send the work in advance so
Sir,
that
I
when you
don't have time, sir.
speak,
I
then
don't have time.
it is having the vision both audio
No.
and visual.
Sir,
Okay, now go ahead.
can you decrease the voice? It's very paining in my neck.
Yeah. Yeah,
Okay.
I put it there in the section 34. Discretion of the court as to the declaration of the status are the right.
Okay, sir. You only read, sir. No.
Yeah, because now you cannot read it.
Any person contented to any legal character or to any rights of a property, I mean, to institute against. Okay, I cannot read it. Can you read it? Because it's too small for me.
To institute against any persons denying or interested to deny his title to such character or right, and the court may in its discretion makes therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief.
Provided.
Yeah, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. Now you go ahead.
Explanation.
Explanation goes, a trustee of the property is a person interested to deny a title adverse to the title of the someone who is not in existence and for whom, if in existence, he would be a trustee.
Okay. Because the DNA test earlier, it was not done in India before prior to 2014. It was supposed to be a scientific test, but it was not legally allowed in India. But after the case of Nandalal Vasudev Badwaik versus Lata Nandalal Badwaik and others, on 6th December 2014, the Honorable Supreme Court has made the DNA test is an accurate and scientific proof of relationship where it can be used to rebut the presumption under section 112 of Indian Evidence Act. It has correlated to two. Whenever we talk about section 34, we should also correlate to section 112 of Indian Evidence Act. It's both complementary to each other. That now why they have done this section 34 and why they have done in section this 112. This is done for the in the interest of the justice for both the parties, where the court shall come to a conclusion on a scientific way to ascertain the truth. That's why DNA test is established, and there is no legitimate paternity than the conclusive proof under section 112 stands conclusively rebutted, which means once a DNA test which is technically proved that the father, the child is the legitimate of the father, then it becomes a conclusive proof. Then you cannot rebut that conclusive proof. Okay, sir?
Yeah.
Now I'll come to section 34 of Specific Relief Act. They are now when you talk about section 4 of Indian Evidence Act, there's something called may presume and shall presume. Now, may presume is a discretionary one and shall presume is a mandatory one. Okay, presumption of facts and presumption of facts and presumption of law shall presumption of facts comes under may presume and assumption of law comes under shall presume. Now, what section 113A of may presume says that 305 and 306 both they talk to each other. 113 shall presume is only 304 of IPC. Okay.
This is Evidence Act.
Yeah. Can anyone tell
Which section I have to show?
Answer?
This is an evidence act. Which section I have to show?
No, you don't have to show, sir. I'm talking. It will be sort of
Okay.
I'll tell the section may presume which all sections come under Indian Evidence Act. Section 86, 87, 88, 88A, 90, 90A, 107, 108, 113, and 114 of Indian Evidence Act come under.
If you just orally give in that way, it will be operated in the eye, in the air. If it is shown on the screen, then it will be having the impact.
Yes, but when you go to conferences and seminar, no one is going to show it on the screen. That screen ka zamana is gone.
See, I'm not giving the 5 minutes time.
Okay,
if the
sir.
5 minutes time would be there, then only 5 slides would come.
Okay.
Go ahead. Okay. Anyway.
Can anyone tell what is the substance injected into the body for narco test?
Sodium pentothal.
Yeah, correct, sir. Correct. You are absolutely correct.
Repeat.
Sodium
pentothal.
Sodium.
pentathlon spelling. Sodium that is a substance which is injected into the body while doing narco test.
Okay.
Okay. Why DNA test is done? DNA test is done in the interest of the individual and the society in crime. Individual rights can be curtailed, but not the society. Article 20, 21, in any circumstances, you can curtail these rights. The famous case law, how it came into limelight, was everyone must be knowing N.D. Tiwari.
Yeah.
Narayan Dutt Tiwari. He was ex-governor of
Andhra Pradesh. Governor of AP, and he was also CM of UP.
Yes. He has a legitimate son out of an illegitimate relationship.
Yeah.
His son has filed a case against N.D. Tiwari to prove that N.D. Tiwari is the father of Rohit Shekhar. Rohit Shekhar is the son. Under section 34 of Specific Relief Act for declaration that N.D. Tiwari should declare that Rohit Sharma is his legitimate son. That was a famous case law when it came into limelight. Now, how this came into limelight? Because of this 2014 DNA test, where the court has ordered N.D. Tiwari to go under the DNA test to prove whether Rohit Shekhar is his legitimate son or not. Done, sir? I'm just giving shortcut. I'm not getting into details.
Okay.
And before the DNA test itself was conducted, he admitted that he was his son.
But now the court has ordered him. After court ordered him, he said he is my son. Anyways, no, he knows it very well. If the court has given order, if the DNA test is done, it is going to prove.
Yes.
Yeah. There's another case law which talks about in Supreme Court in 2010. It was held that every individual has a fundamental right under Article 21 and Article 19(1)(a) to refuse to give samples for DNA test. However, the rights is not absolute, and in the interest of society or individual interest of the other party, the court has its discretion to order DNA test. Section 112, when it is a question of legitimacy of parental and conclusive proof, the court shall be very cautious while granting or disallowing DNA test. Every such order shall be based upon specific facts of the case and in the interest of the justice. The court shall keep in mind that the conclusive proof of section 112 cannot be rebutted by the DNA test, which means once it is scientifically proved, the opposite party cannot rebut that test. चलो ठीक है सर, इतना ही मेरे को बोलने का.
Okay. Now I turn to the Kolikunda Sharad Babu and he will deal about the bounced checks.
Yeah.
Okay, which one should I show? Yeah, this is the first one, but I don't know. It is not come very clearly. It comes a topsy-turvy the scene. Okay, now you can go ahead.
That is the check, sir, model of check, but in the,
Topsy-turvy,
yeah,
upside down.
it's like that only. A check
ठीक है
is,
सर, क्या it doesn't make any difference upside down रहेगा तो.
and
Okay, go ahead.
the definition of the check is, sir, a check is a negotiable instrument instructing a financial institution to pay a specific amount of a specific currency from a specified transactional. Sir, scroll it down. Your
Okay. Say the point because I was thinking that you are reading the above one. Huh? Okay, now I say you are reading the section 138 of the Negotiable Instrument Act.
okay.
Is it?
A check. Yes. But I
You are
want
reading the check. Where is the
want to
check
give a
definition?
notification, the definition for this check. That's why.
Where is the definition of check here?
Yes,
Sir,
at
why
first
don't
it
you
is
give
there.
why don't you give access to sir? He'll scroll it and he'll explain it instead of you. One is talking, one is scrolling. There'll not be any coordination.
No correlation is there, definitely. What I have shown, you should have to speak the same thing. Or it's a gist.
So
It's
just
a document
definition
one.
of a check is a negotiable instrument instructing. Keep it like that only, sir.
Okay.
Like that. When I want you to scroll it up, then you can scroll.
Okay.
A check is a negotiable instrument instructing a financial institution like bank to pay a specific amount of a specific currency from a specified transactional account held in the drawer's name with that institution. Both the drawer and payee may be natural persons or legal entities. So a check may bounce if it has expired or if there is a problem with the date of issuing it. The issuer may choose to stop the payment. In that case, too, the check is considered as dishonored. There could be various other reasons for a bank to dishonor a check. A check bounce is an offense under Section 138 of the Negotiable Instruments Act 1881 Act, punishable with a fine which can extend twice the amount of check or imprisonment for a term not more than 2 years or both. So twice the amount of the check, it can extend up to it, or it may also extend up to imprisonment for a term not more than 2 years. And sometimes it is twice the amount of the check as well as punishment for imprisonment for more than 2 years, not more than 2 years. A check bounce is an offense under Section 138 of the Negotiable Instrument Act 1881. Again, punishable with a fine which can extend to twice the amount of the check or imprisonment for a term not more than 2 years or both. When the payee presents a check to the bank for payment and the check is returned unpaid by the bank with a memo of insufficient funds, then check is said to have bounced. For example, you are drawer and you have given me a check, and when I present it in the bank, if it is unpaid to me because of lack of sufficient funds, then the check is said to be bounced. A check bounce can occur for several reasons, but if a check bounces due to insufficient funds in the drawer's account, it amounts to an offense under the Act. The bank must reject the check presented for payment with a written memo stating the reason as insufficient funds. Returned due to lack of sufficient funds. In such a case, the payee of the check can issue a check bounce notice to the drawer demanding to pay the check amount. And if I am payee, I can issue a check if you are a drawer to pay the check amount if it is not honored.
Excuse me. Now, can you explain who is the drawer, who is the drawee, and who is the payee?
Yes, sir. Suppose you want to issue a check on the name of me,
Okay.
for example, then you will become drawer,
Okay.
and the drawee is the bank. Drawee is the bank.
And whose check I am issuing?
Sir, it is very
Yes,
simple.
you
No,
are
let him
issuing-
take. Let him give the explanation. Then I will turn to you.
You are issuing your check.
Yes.
You are drawer,
Okay.
and you are issuing to me. I am payee.
Means writing your name on the check.
Yes, yes.
Okay. Drawee is the check which is belong to a particular bank.
Where I am going to get that money, that is dry bank. Usually
Okay.
say that is dry bank.
Okay. If I have the four different checks, means four different drives are there. If I write the check.
Yes, yes.
Agreed. Yes. Venuna, do you want to add something?
No, you got confused between drawer and drawee. Now, I'm saying to say is that it is simple like donor and donee. Donor is a person who donates and donee is a person who receives. The same thing you apply the formula.
But the third person is there who pays the money.
Yes, yes, yes.
And that's why I want to make it out.
Yes, yes, yes.
Okay.
Is
Next.
it clear now, sir?
Yeah, no, I got it. Drawer means a person who writes a check is a drawer, and drawee means where the check is belong to a particular bank is
You are
drawee.
the owner of the check.
No, you're mistaken. Not the person who writes. The person who has an account and who's giving the check on his name to other
The
person.
account holder who is having a power to write the check and it should be a particular bank is a drawer. The check belongs to the name of a particular thing is a drawee, and the beneficiary is the payee. Am I right?
Yeah, yeah.
Good. Go ahead.
Now, for various reasons, the check may bounce, and the reasons are insufficient account balance. We have already discussed. If there is not enough balance in the drawer's account to make the payment of the check, the bank will reject and return the check to the payee with a memo stating insufficient funds to pay the check amount. Now, expired validity of check, that is second reason. Once the drawer issues the check, it must be presented for payment within 3 months. The check, scroll up, sir.
Yeah.
The check expires if it is not presented to the bank within 3 months. So within 3 months, it should be produced in the bank. Otherwise, the day on that expires, the check's validity expires. If the expired check is given to the bank, it bounces. Overwriting. If the signature of the drawer or check amount or any other statement has been overwritten on the check bounces for overwriting. So if the overwriting is there, if something is written on already written signature, or if any correction is there, then it will not be honored. It is our real experience.
Excuse me. Suppose if the rewriting is there, Bennett, if the drawer again signs.
No, not valid.
No, we're not valid.
You cannot write any single word rewrite on a check, or you cannot do double signatures. Earlier, it was supposed they used to accept, but after the amendment in Negotiable Instrument Act, from 6 months to maybe to 3,000, during that time, they made all these amendments. No rewriting, no double writing, no double signatures.
Agreed. Okay, next.
Next, damaged check. It will also be dishonored or it will also bounce. If a check is damaged or disfigured and the details are not visible or have marks or stains, the check will bounce. Now, signature mismatch. If the drawer's signature is unclear or absent or does not match with the one in the bank's data, then the check will bounce. So very easy reasons, sir. We can easily understand these.
Because sometimes even the drawer goes to the bank and he signs it. And again, they say, sir, your signature is not tallying with our data, which is a specimen is put it over there. And if I show that I am the account holder, can I make a fresh signatures again? for
No.
continuity of
Yes,
the account?
Your question is different. What sir is saying is different.
Yes,
You're
no,
saying-
that is over.
Generally,
I myself went to the bank
Yeah.
and I want to draw the amount.
Okay.
And I wrote the withdrawal slip.
Yes.
Or I gave the check to himself.
Self check.
And he said, sir, your signature is not tallied. I said, I am the account holder. This is my passport. This is my Aadhaar card. This is my proof.
Mm.
That instance, the banker said, sir, could you make another signature? So he took my 3 specimen signature and he put it in the data.
Okay.
it's generally
Can I-
they won't
Can I answer
object,
that?
sir. They won't object, sir.
Because you're withdrawing from your account to you only. You're not giving. to
Yes,
someone
yes.
else.
That's why I'm giving the. I myself went to the bank.
Mm.
Your photo will be there, sir.
Okay.
So he will also check it and your signature. Then even if it doesn't tally, then I have experienced it 1 or 2 times. He said, sir, your signature doesn't tally with the signature that is here. No, sir, I am the person, I am the account holder. Then when I explained, he didn't object.
Kulukanda, you sent me the 2 files. When I observed it, the 2 files are the same or different.
Same,
But where are the cases?
no cases. I took me a lot of time for me because the cut and paste did not work out properly.
Actually, I prepared my own thing, and when I want to trace it out, I could not trace it out where I kept the file. I'm searching. I know that I put the negotiable instrument, notes. I told it, notes, negotiable instrument and notes. But when I make it out here, it is checking from the different data. But it is in a word format. Negotiable instrument.
Everything went against me, sir.
Yeah. But doesn't matter because generally one should be alert enough before we start the class. Let we check that where we kept our file. So that is very important. But anyway, I am thankful to the Gausia. Are you present, Gausia? Unmute and give me the answer.
Yes, sir, I am present.
Very good. I appreciate. Gausia, did you
Yes.
say anything on the negotiable instrument?
Right now, I can't say, sir. I didn't prepare.
You did not read. At least can you say what is the section deals in the dishonored check or bounced check?
Section 138 and
Very good,
punishment
very
is
good. I
under
appreciate.
142, sir.
Do you remember any case law, check bounce case law?
Sir,
Right
check
now,
bounce
I
case
couldn't
law, there are
recall,
many
sir.
case laws. They're not
Yeah,
check bounce case is like a peanut one. हर गली में जैसे बहुत सारे लोग रहते हैं ऐसे check bounce.
But there are landmark case law is theirs.
I know they're landmark case laws, but no, that doesn't hold because this is a regular reference to the courts. So no one quotes any judgments in 138.
Like if you ask me, what is the landmark case law in the negligence? What do you say? Anyone? Including the other two participants, other two.
Reliance and Fletcher.
I said, repeat the question. Which is the landmark case law where the negligence has developed?
That is Bhopal Gas Project.
No. Venunath,
हाँ सर अभी मेरे को एनए में घुस
Gausia,
Oleum,
I think Reliance versus
Volume
Fletcher,
gas.
Reliance versus Fletcher is the landmark case law in the strict liability.
सर उन्होंने सर ने ऑलरेडी पहले बताया आपको सर ने ऑलरेडी बताया आपको
क्या बताए?
रिलायंस वर्सेस फ्लेचर बोल के बताया
There is a strict liability case law. It is not nowhere related to the negligence development case law.
सर जाने दे सर अभी 138 पढ़ेंगे सर अभी
Say pass on.
यस
Pass
सर
on, sir.
we are losing the.
Donovan versus Stevenson.
Yeah.
It is the landmark case law. Without it, no negligence will come out. Whenever you say the negligence, you have to cite this case law first.
Donog versus Stevens.
Yes. And you know the facts of the case law. You know the principle laid in the case law. Am I right?
It will come under law of tort, sir.
Yes, it is a come under the law of torts, but the negligence development has come from there. And generally, when you say the negligence on the part of it, no, people will use this case law. Because this case law shows the 3 or 4 principles. Number 1,
Sir, any
love
act-
your neighbor. Who is your neighbor? Here the neighbor is, in this context of the case law, consumer.
Sir, but law of torts is not there in our.
Yeah, no, law of tort is not there, but I am giving it to a certain extent the knowledge to you because I could not say. Okay, if you rewrite on the instrument, is it not the negligence on the part of you?
Yes, sir.
No, sir, it may happen when we write, the ink may be not properly coming out or something like that. Then in a bit of alertness, we may write it again. That is a moment of slip. That's all.
Whether the negligence element is appeared in the crime or not.
We cannot say it certainly as a crime.
No, for instance, you say dishonored check. It is a civil wrong or a criminal wrong?
Criminal wrong, sir.
Then what made it to make the criminal wrong if there is no negligence on a part of you?
Just you simply.
Either you say negligence or you say rashness. No, we don't say rashness, but we will say inadvertent act. That is the terminology we will use it. Or can we say the carelessness? Or can we say the oversight?
It's better. The last one is oversight is the apt word, I think.
Okay, because that is a genus and species are different. In which context it is done, it can take the shape as a civil wrong and sometimes it can take the shape as a criminal wrong. Srividya, if you are present, I say you are welcome.
But she is not welcoming us.
But she wrote as SREE, that's why I found it is Srividya.
Sir.
You want to add anything?
Let sir continue this thing. We'll see later on who's going to come, who's not going to come.
You want to add anything, we can add. You said, do you want to say that what is the difference between order and rule?
Sir, 138 खत्म करेंगे sir पहला.
See, my file, I could not trace it out. Still, we do have time.
Sir, लेकिन 138 खत्म नहीं हुआ अभी तक.
क्या ना खत्म हुआ?
इतने जल्दी खत्म हो गया 138.
138 as per the Kolikonda, it is over. You want to add anything, you can add.
138 is a big subject.
You want to add anything, you add.
Sir, don't scream, sir.
No, what he says is it is a big subject.
I know it, because he did not prepare the cases and he did not make it out because of the shortage of time. At least he has thrown some light on that, on what are the grounds would be there where the check will be dishonored. If anybody wants to add anything, you can add it. Still, we do have in your hand at least 5 minutes.
Sir, I have one doubt, sir.
Yes.
I think a presentation of check is within 6 months, sir. But just now I came to know that we have to present it within 3 months, sir.
No.
Then
The
what is the
lifetime.
Let her speak first.
Is there any amendment regarding that?
Yeah, now you speak.
The check, earlier it was 6 months. Later on, the time has been reduced due to the duration of the length of the time. They have made it to 2013. After I forgot the amendment which year they have made it under the Negotiable Instrument Act. It is 3 months. Any check which is stopped either for closing of bank account, handwriting difference, the drawer cannot say this signature, this handwriting is not my handwriting, even though the handwriting may be different. Then also he is liable under 138. He cannot say my signature, this is not my signature or this is not my handwriting. It is very clearly given by the guidelines by the Honorable Supreme Court. And once a case is filed under 138, can a person do compromise or settlement in front of the court?
Yes, sir. They are compoundable offenses.
Compoundable, but what are the guidelines? The Honorable Supreme Court has laid certain guidelines for compounding of offense. When even the case starts, even when the case starts, also you can compound the offense, not during the trial or before the trial. For 138. And whenever any check is issued by the company and the check gets bounced, there's something called after 2013 in the Companies Act, lifting of corporate will. I don't know how many of you know the terminology lifting of corporate will. In 2013 amendment, they've made it very clearly. Any director who, if he has signed any check on behalf of the company, and after the company goes into liquidation, they are not held liable. Once the moratorium starts under IBC, Section 14 of moratorium, when it starts, all the directors are exempted from criminal prosecution under 138 of Negotiable Instrument Act. But what the lifting of corporate will act says is that any decision taken by the directors on behalf of the company, the directors are responsible. Now, how do you contradict two statements? So whenever anything there is such kind of contradiction, hello?
Yes, yes. Please go ahead. Because
Yeah,
I've shown the validity of the check to reduce to from the 6 to 3 months. Once you clear it, then I will throw light on it.
Okay. Whenever there is any conflict between Companies Act, NI Act, then the IBC, Insolvency Banking Code, which is related to 130 related to Negotiation Instrument Act, Insolvency Banking Code prevents all over acts. जितने भी acts, Companies Act है, Civil Act है, no prosecution can be done on directors as per the Insolvency and Banking Code. That is the most powerful act in India as of today.
Repeat.
Insolvency Banking Code, IBC. Okay. Section 14. Once Section 14 is done by the bank, NCLT bank.
The person is protected.
It is called moratorium. Section 14 is moratorium. Once moratorium is done, so all the directors who have signed the checks, they are exempted from criminal prosecution. Only the company is liable, but whereas an individual is criminally liable and is
Gausia, mute. Gausia, you mute it because I could hear the sound from you. Yes, continue. Venunat.
Yeah. Section 14, what IBC says is that moratorium, once a moratorium starts, no case can be filed against the company in any court of law. Let it be labor matter, negotiable instrument matter, or any matter. No case can be go against the company. And as far as 138 is concerned, they are exempted for criminal prosecution. The companies are liable for that, not the directors.
Okay, Gausia, if you want to ask anything, you can ask now.
Yes, sir. Sir, 138 says that we have to present the check within 6 months or prior to its validity. Then what is the prior to its validity means, sir?
How
give reply. Venunat, give reply.
Okay. What you're saying is that from it is not 6 months, it is 3 months. What you're talking about is much longer back. It was 6 months. Now it is 3 months.
I put on the screen. You could see it.
Yeah. Now you mean to say the validity?
Yeah.
Let's presume if someone has issued a check on January 1st, 2022. So uska time hai 3 months. So that person has to present before the expiry of the last date of the check, which means 31st March. I'm presuming,
Yeah.
Which means 31st March ke andar he has to present that check to the bank for the money. That is called the last day. I hope I cleared the question.
If it is false on the day is a holiday, at that instance, General Clause Act is very clearly mentioned.
But General Clear laws mentioned for contracts, not for Negotiable Instrument Act.
So, suppose if it is a holiday, the last date is holiday, he should have to present before 1 day.
He has to present before 1 day.
Okay.
Unless and until if the bank is closed due to bank strike by its employees.
Under the negotiable instrument bank, the bank is closed on particular day.
If the bank is closed on that particular day, then 1 day it can be extended.
Not
Not
1 day before he should be present. Not 1 day before he should present. A dryer should have to present, or a beneficiary has to present the check.
Yes. But Sunday आया त्योहार आया ऐसा नहीं, उसका डेट खत्म हो उससे पहले करो. But only when there is strike, and that strike should come under the Negotiable Instrument Act, then only you are exempted from that.
That means that the Negotiable Instrument Act, General Class Act will not be applicable.
Yes.
Is it clear?
Yes, sir.
Gausia, you want to ask any other thing?
Nothing, sir.
Gausia, did you receive the letter from them?
I
Email.
have to check once, sir. I will confirm after checking, sir.
Okay, because I told the people, I don't know whether Sarnath, Venunath has seen or not, because there is an international webinar would be there on the 18th September that I encourage all the people to write the paper, submit the paper on it. But everybody here saying that, sir, Scopas, you have to write it. Okay, Scopas, you have to write it. When you are trying to get the promotion, at the time the UGC recognizes only the Scopas. But as far as the knowledge is concerned, you can show in the different field also. But only the promotion is concerned that you can show in the Scopus. Because UGC says such a thing now. Yes, this is the other information. But anyway, I don't know why today, of course, I started a bit late because in the searching the file, I'm searching the file of the Kolikonda also. And that's the reason the Cisco WebEx is not stopped its duration. So let me take the presenters, because I requested the group, at least could you prepare the calendar. Nobody is prepared, even nobody is present also. It doesn't make any sense. It doesn't make any different in our teaching style. If one person also get benefited our lecture and we feel that our mission is fulfilled. With this, I would like to say thanks for listening to us, and I would also say the SR Venunath to thank. But Venunath, if you have to provide us the material and we would show it on the screen, that will have the double impact to our participants.
I'll do it from next week. Tomorrow, day after tomorrow, another day. 3 days we have Ganpati. I will not be attending class online.
Okay. But
come on Monday.
I don't know whether the participant is there, Sri Vidya, because I saw the Sri, but now I could not see the Sri. I saw only the three hosts and one participants. With this, I would like to stop my today's class. And thank you very much. In Kiswahili, we will say the Asante Sana. And end of the meeting, I will make it out now. Have a pleasant good night.
Thank you, sir. Thank you.
Yes.
Thank you.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।